There are now enough elected votes in Congress to release the Epstein files. And basically, when the shutdown is over, under the current newly elected membership of Congress, there should be the 218 votes to override the Republican opposition and actually release new Epstein files. So that is a big headline. I'm going to get into that in this breakdown. I'm Ari Melber, the MSNBC anchor, chief legal correspondent. I'm also going to talk about, in this breakdown, this hat, which Steve Bannon sent me, and speaks to one of the big problems we have in America, where you have politicians openly talking about trying to end democracy as we know it. So I'm going to get to that in this breakdown. But we begin with the Epstein files, and we actually are at a turning point which, but for the government shutdown, would mean that we have now the votes in Congress to see the rest of what DOJ under Donald Trump is hiding about Epstein. That's a major development. There are basically very few ways in Congress to get something for a floor vote without having leadership wanting it. That's just how the congressional rules have always worked in the modern era. And so the Republicans under Speaker Johnson have gone along with Donald Trump to hide any new release of Epstein files, material from the case, material that could be meaningful and important for the public to know, or even raise questions about how he died, what other avenues and leads were not pursued. And so that's usually where these things stop, and the Republicans, backed by Johnson, have tried to stop things there. But there are now 218 elected votes to release the Epstein files. What does that mean? It means that there's a discharge petition, there's a lot of congressional language about it, and basically because of this new special election, there has been a new member of Congress elected that's going to join and would be that last final vote that they were waiting on because they had to a 17. Mike Johnson is trying to buy time and is refusing to seat that person, Congressperson-elect Grijalva. There are now lawsuits on that. I'll say just briefly because that's a new kind of development. The precedent is not very good to get the courts to interfere and sort of fast track seating that new member of Congress. Johnson is not seating her and says that when the government reopens, he will do so. That's a lot slower than he's seated other members who were newly elected in special elections in Republican districts, basically, with a Republican one. But it's not necessarily automatically unconstitutional. And the courts, I can just tell you, generally don't like to jump in and get involved. They have off-ramps to avoid it, political questions doctrine. You have to go all the way back to Adam Clayton Powell, the Harlem congressman who did win an election, and the Congress was trying not to seat him, and the Supreme Court basically intervened. But it's rare. What does that mean for the Epstein case? It means that you may not get any action on this till the government reopens. If Congress is not forced by the courts to do something, then however long the shutdown goes is how long this goes. I want to touch on what the Epstein files could actually yield, and then turn in this breakdown to the talk of Trump 2028, which is blatantly unconstitutional, illegal, tantamount, similar to a coup, if you actually tried to get a third term for any president. But on the files themselves, all we know is that the Justice Department under Trump has backtracked completely and broken the vows of what was the claim by both Donald Trump as a candidate and the people he put in charge at DOJ and FBI that they would quickly release these Epstein files, and they haven't. So what's actually in them is itself obviously unknown. This could be, and I want to be clear, a case where everyone's excited to get them, and if you actually got the files, there might not be anything all that substantive or interesting. But one reason that is not currently the best guess, and that's all it is really, is a guess, is that if there was some easy tranche or pile of files that didn't have anything really hot in it, and there's been this much pressure and Trump had campaigned on releasing it and Bondi had reviewed it, well, then it might be in your interest, legally, politically, and otherwise, to just release it, maybe with some redactions, and then you could say you have. So the reason, which is speculative, that many people, legal experts, people who follow this case, even putting aside politics or conspiracy theories, the reason a lot of people think there might be something in it is that A, they're acting like there's something in it because they're going so far and taking heat and risk to hide it. And B, there's been reporting in the Wall Street Journal elsewhere that there's already some things that are interesting, like Donald Trump's name recurring, which doesn't mean legally that he's accused of wrongdoing or did anything wrong pursuant to this case, but it does mean that the Journal has sources, they say, standing by their reporting, that implicates him in it in some way. We don't know whether that actually is based on his prior social history and dealings with Epstein back in the day, or more recently, the fact that he's the former president. Remember, he was the president overseeing the Justice Department when Epstein suspiciously died in prison. There's also, I'm just looking at some notes I wanted to get into in the breakdown, there's also these big questions about blackmail. Trump's own cabinet official, Lutnick, kind of got everyone all excited and outraged again when he said that Epstein was clearly blackmailing people. Well, if he is at all correct, and he knew Epstein personally and is in the Trump cabinet and has more sources than a lot of people, if he's at all correct, that raises the question of why the DOJ, under both parties, by the way, because there was time to look into this, both in the original period, in the DOJ period after Trump left office, that's the Biden era of Merrick Garland, and then again recently, why hasn't any DOJ pursued those claims in those potential cases? Blackmail is referenced in the Pam Bondi, a very controversial, very kind of thin 2-page memo that says there was nothing to see here, no cases. But these files, if they name, for example, people who paid Epstein a lot of money, sometimes in very suspicious circumstances, then did they look into a blackmail case there? Did they look into whether people were either victims of extortion or were participants, perhaps, in an alleged conspiracy? Sometimes if you're being blackmailed, you could be innocent of any crime. Other times it could be a crime, allegedly, that's being used to blackmail the person. So these files, if they even make vague or possible references to that that type of activity, that action, that's something that the DOJ would be pressed on whether they should have investigated or should now. And then Epstein's death conditions. This is something that maintains a lot of interest to people because there were so many suspicious details. I've reported on some of this, as have many others. The Miami Herald has done a lot of reporting on Epstein, both in the early period and then after his suspicious death under the Barr Justice Department in the Trump first term. But among other things, that was investigated by the Inspector General, that's sort of the watchdog of the DOJ, which found that Epstein had reviewed his last will and testament and signed it in front of his lawyers right in the period before the period that he was found dead in his cell, that he made an unauthorized phone call, that people involved in the oversight of his cell specifically in the BOP, the Bureau of Prisons in that era, had lacked candor, that's sort of the legal term, but ultimately basically had lied to investigators, which raises the question of why. Were they just covering up that they let someone die in custody if it was a suicide, which in that case is bad, or were they covering up something else? So the Justice Department's Inspector General did that investigation and even found those negative things. It is an open question whether you really got access to the full files, whether there would be other details, questions, or things that are somehow suspicious about the circumstances of Epstein's death. So we just don't know. And again, I say that not as a cop-out. I say that to be very clear, because some people like to maybe lean into what you don't know or use it to stoke interest. I'm not at all interested in trying to do that, but to say that from a legal and investigative and journalistic view, those are the types of questions you have going in the files. All right, I want to turn here to the next thing in this breakdown. I'm doing these legal breakdowns. You can always subscribe to my YouTube channel, Ari Melber, like and subscribe and keep up with me. But this is a note I received from Steve Bannon, which says very simply, my name, Trump 2028, and is signed. This came with this hat. And I mentioned this now. He sent this a few weeks back, and I didn't mention it in our coverage, and I don't think we should always over-respond to these types of things or trolling. But now that the president is again discussing an illegal third term, the Speaker of the House, Republican Mike Johnson, dismissed it and said there's no path to that, which is fact-checked true. Legally, there is no path. And this is all back in the news. I want to discuss that as sort of my second topic in this breakdown. Again, just looking at some notes I wanted to share with you guys. The first thing politically that we have to keep in mind is what is true and what the goals are. So if somebody is trying to trick, or the word of the year now, troll you, and you care about truth and evidence, what's really going on politically, before we even get to the obvious constitutional fact that you can't run for a third term. And I think first is Steve Bannon, who's someone that I've interviewed and reported on and dealt with, is a political communicator. That's something he prides himself on. And he continues to bring up the idea that Trump could be something other than a lame duck. And I say it that way because even before, again, the law, Bannon, who was the leader of the homestretch victorious 2016 campaign, who's been in and out of the White House, may be doing something that is more political than practical here. Meaning, whether or not you get to an attempt to hold power past 2028, which you have to take seriously given everything going on, and I'll get to that. First, you have to look at what is often called in political science the Overton window, which a lot of people know about, but it's basically the idea that if this is the realm of what is accepted sort of traditional or conventional ideas in political debate, and boy has that changed lately, but if this is the idea that you want to go and shoot out of that, you want to be putting ideas over here to expand the window of what's acceptable. And any side could do that. I mean, as a communications tactic, it's actually neutral, that you could do that around this conservative idea that you want taxes not only low, you want taxes to go to zero. Well, no government runs on zero taxes, but just as an example, you could start pushing that idea and get that out there in people's heads so that the negotiation you do offer sounds maybe more rational to some or less extreme than the zero, right? That's just the window. You could do a liberal example, whatever. Here we're talking about something very serious. We're talking about people who were caught trying to overthrow the 2020 election, who were in some cases criminally indicted and convicted. In other cases, we didn't get to trial. Donald Trump in our legal system was never tried on those matters because he actually won re-election when he ran again, as you know, in 24. So in all fairness, some of those were adjudicated, some weren't. But we're dealing with people from Trump on down who did try to overthrow the 2020 election. So when they talk about other plots to mess with the outcome of elections or break laws, we're not starting at neutral. We're starting from the inference of they've done this before, tried it, plotted. But before we get to that, in the Overton window, Donald Trump constitutionally, legally, is a lame duck. Midterms are this year. Maybe he'll do well and he'll be an empowered lame duck, but his time is still running out. And if you look all throughout history, lame duck, when you are headed towards the end of your power as a president, tends to be when you become less relevant. The Congress and others are serving in different terms. Senators are doing 6-year terms. A president who's approaching his last 3 to 1 year left is dealing with people who are very much looking past him. And so politically, there is clearly an effort to make Trump seem like he's going to last longer, expand his power. There's also efforts to do that by abusing power, and we can report on that. I cover that a lot. If you're watching, you probably know about that. But if this is a communications tactic, even introducing the very idea that something illegal that can't happen in a democracy like ours is possible, plausible, that expands it. And then you could imagine if he wants some other thing, some other role past 2028, which I'll talk about in a minute, suddenly that sounds like, according to Bannon's pitch, a middle ground from going all the way out here to the idea that we would end democracy and our constitutional rule. So that's number one. You're normalizing other options if you allow that to happen. And so while we've seen this tactic before, you say something's a joke or you let an outside person float it, then you take it back. It's very unpopular if you tell Americans that you don't respect their vote and you want to end democracy, even for those who are very loyal to Trump on other issues. And so we've seen the limits of that. Trump keeps having people basically float this, then back off it. At one point it was a joke, at another point it's an outside advisor, but it keeps coming up. And so I think that's one part of it. And I mention this because Mr. Bannon sent this to me, and I presume, I don't know who else he sent it to, but he's talking to reporters. He most recently talked to The Economist about it. He's using different methods to put this out there, to normalize and launder these ideas. Trump obviously likes doing that. He puts the hats out when he's meeting with Democrats and other things in the Oval Office. And so that's a bit of the strategy part. The fact that they were caught trying to hold on to power and overthrow the 2020 election is the context for all of this. And I got to tell you, just being clear here in the breakdowns I share, I find it really extraordinary sometimes how the country lived through this insurrection. It became the biggest federal probe in our history.
Tonight we need to slow the noise down and focus on what actually matters. Because when you strip away the outrage cycles, the memes, and the partisan shouting, the Epstein files tell a much deeper story about power, accountability, and whether the American justice system still works the way the Constitution promises it should. For years, Americans have been told to move on, that everything important about Jeffrey Epstein has already been revealed, that his death closed the book. But that claim does not withstand even basic scrutiny. A closed case does not come with broken cameras, falsified logs, missing evidence, and unanswered questions acknowledged by the Department of Justice's own Inspector General. A closed case does not involve a man who controlled vast sums of money, cultivated relationships with powerful figures across politics, finance, and intelligence circles, and died while under federal custody, only for key investigative records to remain sealed years later. And a closed case does not inspire repeated promises of transparency from political leaders who then fail to deliver once they are in a position to do so. That contradiction is not partisan. It is institutional. What matters legally is not speculation about who Epstein knew or what crimes he may or may not have committed beyond those already established. The core issue is whether the federal government fully investigated every reasonable line of inquiry and whether it preserved, analyzed, and disclosed evidence consistent with the law. That includes financial records, communications, intelligence referrals, custody procedures, and decision-making inside the Bureau of Prisons and the Department of Justice. We know from court filings and Inspector General reports that guards falsified records, cameras malfunctioned at critical moments, and supervision failed. Those are not internet rumors. Those are official findings. In any other federal death in custody case, such failures would trigger exhaustive review. Yet in this case, transparency remains partial at best. The Trump Department of Justice sits at the center of this unresolved record. Trump himself publicly promised that the Epstein files would be released. His attorney general echoed that sentiment, and yet during that administration, full disclosure did not occur. That fact alone undermines later claims that secrecy is necessary to protect ongoing investigations or sensitive sources. If the investigations were concluded, release was possible. If they were not concluded, then the public was misled about their status. Either way, the inconsistency matters. Justice systems lose legitimacy not only through corruption, but through contradiction. This is where the broader political context becomes unavoidable. Because the Epstein files are not just about one disgraced individual, they are about whether power insulates itself from accountability. And that question resurfaces now as Donald Trump and his allies float rhetoric about remaining politically dominant beyond constitutional limits, including casual references to 2028 that are legally meaningless but politically revealing. The law here is not ambiguous. The 22nd Amendment bars a third presidential term. Courts would block ballot access. State election officials would intervene. No serious legal scholar disputes this. So why talk about it at all? Because power does not operate only through legality. It operates through perception, normalization, and intimidation. We have already seen how this works. After the 2020 election, claims that were initially framed as questions evolved into pressure campaigns, legal maneuvers, and ultimately criminal conduct. Many of those involved told themselves they were acting within gray areas until courts, juries, and prison sentences proved otherwise. Democracies do not collapse because laws vanish overnight. They weaken when enough people begin treating the law as optional, inconvenient, or subordinate to loyalty. That is why rhetorical boundary testing matters even when it appears unserious. It conditions audiences to accept outcomes that would otherwise be unthinkable. The connection between Epstein and democratic erosion is not conspiratorial. It is structural. When institutions fail to fully confront wrongdoing by powerful individuals, they send a message that rules bend upward. That message does not stay contained. It spreads. It tells future actors that accountability can be delayed, diluted, or denied. It tells the public that truth is negotiable. And once that belief takes hold, every other safeguard becomes harder to enforce. Legally, releasing the Epstein files does not require sensationalism. It requires process. Courts can order disclosure with redactions. Congress can compel production under oversight authority. Agencies can release records consistent with privacy law. none of this is radical. What is radical is the sustained resistance to doing so. Secrecy is sometimes justified, but prolonged secrecy in the face of admitted failures is not neutral. It creates suspicion because it creates imbalance. Transparency does not threaten justice. It strengthens it. And to be clear, transparency cuts both ways. If the files show incompetence rather than conspiracy, the public deserves to know that too. Democracies survive not because institutions are flawless, but because they are corrigible. Admitting failure is not weakness. Hiding it is. The longer disclosure is delayed, the more corrosive the effect becomes, not because of what might be revealed, but because of what the delay itself signals. This is why debunking fantasies about a 2028 coup does not mean dismissing the underlying danger. There is no legal pathway for Trump to remain president beyond 2 terms. That claim deserves to be rejected plainly, but dismissing the legality does not mean ignoring the strategy. The real risk is not an illegal 3rd term appearing magically on a ballot. The risk is a sustained attempt to weaken trust in constitutional limits, courts, and electoral systems, so that when future abuses occur, smaller ones, quieter ones, they face less resistance. Authoritarianism rarely arrives announcing itself. It arrives disguised as grievance, exception, and inevitability. So where does that leave us? It leaves us with a simple but demanding standard. Either the law applies equally or it does not. Either transparency matters or it does not. Either the Constitution constrains power or it becomes a suggestion. The Epstein files are not a sideshow. They are a test of institutional credibility. If the justice system cannot fully account for a high-profile death in federal custody involving documented misconduct, then public confidence will continue to erode. And if constitutional limits are treated as rhetorical targets rather than binding law, then the damage extends far beyond any single election. The strength of a democracy is not measured by how loudly leaders proclaim their innocence or their authority. It is measured by how willingly they submit to oversight, disclosure, and constraint. History is unambiguous on this point. When power demands secrecy, democracy pays the price. When accountability is delayed long enough, it becomes denial. And when denial becomes routine, the rule of law becomes fragile. So the choice is not between outrage and indifference. The choice is between responsibility and decay. Release the files. Follow the evidence. Respect the Constitution. Because justice does not depend on who is powerful enough to avoid it. Justice depends on whether the system is strong enough to demand it. And in the end, the truth does not threaten democracy. Fear of the truth does.